Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hard-working Americans and their families?
You will! This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefits in your benefit plan. Now prepare to learn,
Plan,
save,
and protect with the FIA Group.
Hello, and welcome to the latest episode of the FIA Group's podcast, Empowering Plans. I am John Jablon, and on with me today is Cindy Merrell. Cindy, say hi.
Hi.
She always sounds so cheery. I love that about Cindy. I love recording podcasts with her because no matter how cynical I get, Cindy's always here to bring up the mood. So thanks for that, Cindy.
Of course.
Today we're going to be talking about what might end up being a fairly sensitive topic for some of you. Sorry about that, but it's very hard to talk about state laws with respect to healthcare sometimes without getting a little bit political, a little bit sensitive, but we're going to do our best to stay neutral and just talk about what's going on. Today, we are talking about services for gender dysphoria and transgendered individuals. And we are going to compare and contrast a couple of states, in particular Florida and California, in terms of the laws that they have set forth with respect to services that are necessary to treat gender dysphoria and related illnesses. And as you may have guessed, Florida is one of the most restrictive, and California is actually one of the most favorable for individuals with gender dysphoria. So we're going to talk about those laws. We're going to talk about how they affect insurance coverage and, by extension, you and your clients and your businesses. And then we're going to transition into federal law and how federal law treats this type of treatment and insurance, because most of you listening are probably more deeply embroiled with federal law plans or ERISA plans than state law plans. And we're bringing up these two states in particular, Florida and California, not just for those of you who have groups in those states and who may be impacted by those laws, but also just to give you sort of an indication of what the landscape is like within the country. You know, there are lots of different states doing lots of different things, but we chose these two as sort of the extremes. And because you never know what your state might do and, you know, which level of restriction or favorable laws might end up happening, because there's a lot of room for sort of creativity within state laws, as we'll talk about in Florida and California. So with that introduction, Cindy, will you tell us about the Florida law?
Sure. So the Sunshine State happens to be one of the most restrictive in the country, like you had mentioned. Actually, back in 2023, Governor Ron DeSantis, he signed into law House Bill 254. And what that bill does is it restricts all gender-affirming care for minors, including all the puberty blockers and hormone therapy. And then it also has implications for any adults seeking gender-affirming care. More specifically, it's actually restricting the doctors who provide that kind of care, and including the hormone replacement therapies and or surgeries. What I find most interesting about Florida is it also prohibits Medicaid from covering that care. And when I'm thinking of a lot of people that are younger, they might not have access to a health plan through their employer. A lot of them may be on Medicaid, and they are restricted from seeking any kind of gender-affirming care. As compared to California, which I would love to hear more about, being more the complete opposite, not only the opposite side of the country, but the opposite side of this issue.
Yeah, absolutely. And Cindy, one thing worth mentioning in Florida is that one of the ways that doctors are restricted is that not just any doctor licensed in Florida is allowed to provide certain gender-affirming surgeries and other treatments. You have to be specifically licensed to provide that specific kind of treatment in Florida. So it's severely restricted based on these providers having to jump through a lot of hoops in terms of extra licensure and strict reporting requirements. And so what we've heard is that there are tons and tons of doctors in Florida, of course, but the vast majority of them are not even allowed to provide these types of services. And even many of them who can are kind of too scared to, because they risk revocation of their medical license if they do something wrong. And I think that the prevailing opinion there in Florida is that the state is obviously taking a stance against this type of treatment. So a lot of doctors are worried that the scrutiny is going to be extremely strict, and that, even if they think they're doing everything right and they're, they're helping people and they're jumping through all the hoops they think they're supposed to be jumping through, a lot of doctors are worried that the entities charged with enforcement are going to go sort of above and beyond to try to make sure that these doctors are not providing this type of care. And it's one of those things where states are sort of left to their own devices to make laws here. And we've seen the same thing with abortion post-Dobbs, right? States are kind of all doing their own thing. And of course, there's challenges to those laws. But it's so interesting because when we see a state that's trying so hard to regulate and maybe even do away with this type of treatment, Florida probably could have gone farther, right? I mean, I don't see any reason that they couldn't have just said no gender affirming treatment. No providers are allowed to provide it. Obviously, that would have been more easy to challenge, than restricting it. But we've seen restrictive laws like that in the past. And, it's so interesting to me that Florida...
Comparable to the abortion laws. Yeah. That was interesting. That I felt that way as well. Like, it's not that they didn't take it all the way to the nth degree. And instead, I find it very interesting that they specifically are targeting the doctors providing that care. And one other thing is that they have also prevented that kind of care through telemedicine, which we're sitting here in 2024. It's amazing to me that we would go back and not allow telemedicine for certain conditions. It's interesting to me that they had prevented the telemedicine for this kind of care.
Yeah, the legislative intent behind it talks about how it's, it's very personal and you need to be face to face and all that kind of stuff. But we sort of can't help but get the vibe that it is an attempt to create another barrier, just trying to make it a little bit more difficult for individuals to get that care. And especially something Cindy brought up when we were talking about this is that Florida is not all big cities with tons of providers everywhere. A lot of Floridians are very far from providers, and telemedicine was not really a luxury, but a necessity for many of them. And I got a lot of family in Florida, and they're all in sort of big city type areas, but I've also known a lot of people who are nowhere near anything. And especially when these providers who are allowed to provide the services are so few and far between, getting to one really could be prohibitive.
Yeah, it's a very interesting approach, I think, that Florida's taken on this issue.
Absolutely. And so when it comes to insurance, I think it goes without saying that there is no law that requires insurance to cover these services, because that would not quite jive with the laws restricting providers. So there's no mandate of coverage. Insurance is always free to consider anything related to gender dysphoria to be cosmetic or medically unnecessary. And, that's in stark contrast to a lot of other states that are starting to specifically require that treatment not be automatically considered cosmetic or medically necessary. And, there are a lot of states now that specifically prohibit exclusions for gender dysphoria or related services in the plan doc. And one of those, of course, is California, which is now sort of jumping to the other side of the proverbial aisle, which I guess is getting unintentionally political, sorry. But back in 2021, California passed a law that essentially made it one of the most progressive states for transgender healthcare. And as I mentioned before, California specifically requires that you cannot consider transgender related services to be medically unnecessary. You've got to subject them to the same medical necessity criteria as any other services. You can't have medical bulletins that say, oh, if it's about this, it's medically unnecessary. You can't say, oh, if it's about this, it's cosmetic. You can't do anything like that. And then a year later, in 2022, California essentially made itself a sanctuary state, where it said California is not going to comply with out-of-state subpoenas or investigations that target providers who do provide or patients who seek gender-affirming care. And that's so interesting in today's landscape, too, because, again, to bring up the abortion issue, right? I mean, we've got states like Texas that are passing almost bounty-type laws, whereas California is going in the complete opposite direction, making itself a sanctuary state and saying, if you need this care, you are safe here. We are not going to allow your state to punish you or punish a provider. So it's really interesting that way. I mean, California is really, I can't say it any other way than they're taking a stand. California is really, they're doing what they can to protect this care and providers that provide it and patients who need it.
Yeah. And they're also having their Medicaid is called Medi-Cal. Medi-Cal is as we would expect, they fully cover gender affirming care for those seeking that care. I find that that's just such a difference out there. And it's hard. If I were a plan, it's difficult to navigate that and then square that across with our federal law. And I was hoping we could jump into that, just touch on that quickly. What federal laws out there are impacting this issue?
Yeah, there are a few. So one is the Mental Health Parity and Addiction Equity Act. And at FIA, as you probably know, if you've heard our podcast, webinars, or read our blogs, we talk about this a lot. It has been a very important law ever since the CAA was passed. At the same time as the No Surprises Act, there were new regs on mental health parity, and there continue to be. But one of the things that the Department of Labor has been extremely clear on is that if there are limits placed on transgendered health services, it is not compliant unless there are analogous limits on other types of treatment and surgery. And for the most part, when plans place limits on these types of surgeries, what we overwhelmingly see is that they are not placing sort of the same type of limitations. So not to say that any given plan is necessarily non-compliant, but just be careful with respect to mental health parity, because placing limits on these types of services usually are not going to find their sort of parity counterparts in other services. And then there's also stuff like the Civil Rights Act, specifically Title VII, which prohibits certain types of discriminations, including sex discrimination. And there was a Supreme Court case, that's Bostock v. Clayton County. Gender identity is a form of sex-based discrimination. So if a plan or employer or anybody else with the authority to do so is limiting benefits or otherwise treating people differently because of their gender identity or care they need as a result of their gender identity or gender identity disorder, as it logically follows, that is now considered a form of discrimination under Title VII of the Civil Rights Act. And HHS has been very clear that they are going to enforce this and adopt this stance and sort of make it a thing. They're not going to just go on and let things slide, and there's always going to be stuff that goes under the radar, right? But they are looking for it. They are trying to enforce it to the extent of their abilities. And then there's Section 1557 of the ACA, which doesn't necessarily apply to everybody, but it applies to people who receive federal assistance. And the same type of discrimination is also prohibited for entities subject to Section 1557. And another case, a really interesting one, and we can give you more information on this if you'd like, but a really interesting case has established that it is not just health plans or traditionally covered entities that are subject to 1557. It can be a TPA as well. So if you're a TPA, just make sure you're careful. If you're subject to 1557, you could potentially be found liable for discrimination if you are processing claims in a discriminatory way, even if you're just doing what the plan says. And we're seeing more and more of those fiduciary cases where TPAs are being held as fiduciaries, and this discrimination, it's no different.
A lot to consider right there.
Absolutely. Cindy, so what do you think about this, right? What does it tell you where the states are doing one thing and the federal government is sort of taking its own stance? I mean, what do you think? Do you think the federal government is trying to side with certain states, or do you think that they're just sort of independently doing what they think is right? Or what's your take on this?
Well, I think that we're definitely going to end up in front of the Supreme Court because we are seeing these more and more often. These cases are coming up. What's interesting to me is I think eventually it's going to all come to a head and everything has to get put into an alignment of some sort. But what it seems to be is it's heading towards this gender affirming care. If I were to predict it in the future, will be required because of what we're seeing coming out of the federal government. And a lot more states are heading towards that direction. But I wish I had the best fortune telling. That's just what I'm seeing and it's where I'm guessing. How about you?
Well, so I don't know, but I love your answer because my question was essentially, why do you think the federal government is doing what they're doing? And you're such a lawyer. It's a perfect answer. You just skirted it entirely. And I love it. I love that answer. I do think that the federal government is taking an independent stance. I think, states can do what they want, but the federal government is sort of dead set on considering this to be a form of sex discrimination or gender-based discrimination. And I don't see that changing anytime soon, just like you. As we get some circuit splits, hopefully the Supreme Court can weigh in on this so we can at least know one way or the other. But for right now, if you've got state law plans, just be careful because different states are doing different things. And the legal landscape, as always, right, is changing. And so who knows what's going to stand, what's going to get overturned, what states are going to do what. We're keeping our eye on the pulse. We recommend that you do too, but stay tuned and we'll give you updates when we get them. And I guess that's all for me. Cindy, any closing thoughts?
No, I really appreciate today's discussion, though, because I do think that there's a lot out there that we need to learn.
Absolutely. Well, thank you, Cindy, on behalf of myself, John Jablon, and Cindy Merrell. Thank you to all our listeners, and we'll talk soon. Bye.